Good morning. Are you Juan David Sanchez? And Mr. Sanchez is currently on probation for the offense of driving while intoxicated, third or more. A motion to revoke was filed with the allegation that there was a new offense of driving while intoxicated from April 15th of this year in Wharton. Is that Wharton County or anyway? It's in Texas. And then also that on April 15th, 2025, he was driving a vehicle that was not equipped with an ignition interlock device and that he failed to abstain from the use of alcohol. Mr. Franklin has filed a motion asking that I set a bond. There's currently not a bond on the motion to revoke probation. Do you intend to call your client as a witness or no?
Only if necessary, Your Honor.
Go ahead, and I'm trying to find, give me just a second. I'm looking for the old PSI.
I have my copy if you need it, Your Honor.
This one may be old enough where it didn't get,
It was 2019.
all right, you can go ahead, Mr.
Your Honor, we
Franklin.
have not been provided with a copy of the old PSI. That was not produced to us. So that was one of the issues I think that he's addressing. We also supplied
Mr. Nichols,
right up, I'm sorry.
go ahead.
And, we filed with our motion about a dozen letters in support.
And I have received those and take judicial notice of the court's file that includes those as well. Thank you.
Thank you, Your Honor. In assessing whether Mr. Sanchez is a flight risk, I think the support from his community, from his family, helped provide evidence that he's not a flight risk. So the court should then turn to the prong whether of what threat he may pose to himself or others. In this case, the underlying offense was 2019. The motion was filed based on a violation, true, but there were not other violations as far as not reporting or failing other tests up until now. So that's been effectively 6 years that he's been compliant. We'd also like for the court to take note that the other offenses that are mentioned go back as far as 1992 to 1995, 2001, etc. In other words, it has been, in some instances, decades since those offenses occurred. And although we're not downplaying the severity of what Sanchez is currently charged with, we do think the court should take into account, as regards the threat to himself or others, the fact that the other causes are, in some instances, over 30 years old.
What's the status of that case in Wharton? Does anybody know?
Your Honor, it is my understanding, and I don't represent him on that case, but my understanding is that it is pending because this one fell first in the queue, so he was sent here first.
Okay. So they're going to wait for us to see what I do, I
That
guess.
is my understanding, Your Honor, but again, I don't represent him on that, but that's what I could glean. I spoke to a lawyer that he conferred with there, but he did not end up hiring that lawyer, so he couldn't speak,
Okay. All right. Mr. Nichols, what's the state's position with regard to a bond?
Judge, my main concern is him driving a vehicle that doesn't have an interlock. So we have no idea how much driving he's done. It sounds like the only reason we found out about this violation is that he got caught. I doubt that this is a one-time event of driving his wife's vehicle without an interlock. And so to protect the community, I'd ask that if the court does set a bond, that it be high enough to protect the community from his repeated driving while intoxicated.
Your Honor, may I respond?
Sure.
First, speculation as regards any other instances is probably not admissible. But secondly, there are measures that the court can take in assigning bond conditions to monitor Mr. Sanchez in such a way that
But he had probation conditions that were meant to monitor him.
Your Honor, as regards whether he's drinking, for example, there are scram devices and other devices that constantly test for alcohol in the system. The scram device, for example, tests every half hour.
So here's where I am on this. Mr. Sanchez had at least, this is his fourth conviction that we know of for a DUI. I know there were some other arrests that we didn't have the disposition. Looks like, at least according to some of the information I've received, that there's been 7 or 8 arrests. This was a cap.
Including those as well, Your Honor.
Okay, that's overruled. think with regard to setting bond under 17.15, I'm able to take into consideration everything that is at my disposal. And in fact, I'm required to take into account everything that is at my disposal with regard to prior offenses, with the most recent bail reform, as well as the ones from a couple years ago. So I guess my worry isn't necessarily the reporting or him fleeing. My concern is for the safety of the community. And this was a cap of 8 years when I gave him this probation, probably against the argument of counsel from the state, and gave him this opportunity. He's on probation, commits another. We're lucky we're not here for an intox assault or even worse. I am going to deny the motion for a bond at this time. If there is any likelihood at all that I would leave Mr. Sanchez on probation, it would absolutely be with some type of treatment. And so I'm not going to allow him to get out and even with the scram or anything else and put the community in danger. All right, we'll get it set for an announcement within about 30 days or so, and then we'll see where we get on the case.
Thank you, Judge.
Thank you, sir. You can go back with the bailiff.
Your Honor, may I be excused?
Yes, sir, thank you. I'm thinking about something else. All right, sir, are you David Tillman? And, all right, so it looks like there is we've got cause number 22-40540 and 24-0536. And will your client waive the formal reading of the motion and the indictment?
Yes, ma'am.
Just a second to get there. Mr. Tillman, in cause number 24-0536, are we going on count one only?
Yes, Your Honor.
God bless you. The state has elected to proceed on count one only. It alleges you committed the first-degree felony offense of aggravated sexual assault of a child from August 15th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yeah.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
Also, in this case, do you understand that you will be required to register as a sex offender? It looks like you've signed that paperwork, and have you gone over that with Mr. Lewis as well?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Tillman is not competent?
No, Judge.
All right, Mr. Tillman, in cause number 24-0536, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated sexual assault of a child. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
And it's a little confusing, Your Honor. The motion does not contain the offense he just pled guilty to, because the dates, the new offense predates him
Gotcha.
being put on probation, so it's
Okay.
not part of the revocation.
Gotcha. Thank you. All right. And then in cause number 22-40540, I have a motion to revoke your community supervision. Shows that you were placed on probation May 1st of 2023 for the offense of unlawful possession of a firearm by a felon. And that was a 10-year term in prison that was probated for 6 years. Is that correct?
Yes, ma'am. That's true.
And it alleges that you violated your probation. Count 1 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
That's true.
Count 2 alleges that you failed to provide verification of entering and successfully completing the MRT, the Moral Recognition Therapy Program. Is that true or not true?
That's true.
And then count 3 alleges that you are behind in your court-assessed fees. And is that true or not true?
That's true.
Did you enter your pleas of true to each of those counts freely and voluntarily?
Yes, ma'am.
And did you plead true because those counts are actually true?
Yeah, true.
I also have some documents here on the computer in that case that have your signature on them that the state's marked as exhibit number 1. Did you also go over these with Mr. Lewis?
Yes, ma'am.
And do you fully understand them as well?
Yes.
And do you understand, again, if I follow the agreement in this case, you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1. It's admitted. All right, Mr. Tillman, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time revoke your probation. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These two cases will run concurrently, which means together at the same time. I'm handing you now, in each of your cases, the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. We already went over that when I put you on that probation. I just want to make sure you understand, based on the judgments in both of these cases, you are ineligible under Texas law to possess a firearm or ammunition. If you have any questions about that, make sure you read that document and talk to Mr. Lewis.
Yes, ma'am.
All right, good luck to you, sir. You can go back with the bailiff.
I have one question.
Yes, sir.
Does the time I get credit also include the time I was in Oklahoma?
So the time that you will get credit on is any time that you were either in our custody or that we had a hold on you. So if we had a hold on you from Jefferson County and you were in some other place being held, then yes, you would get that. If we did not have a hold on you, then you would not.
All right.
Okay?
Thank you.
Yes, sir. Good morning. Are you Darren Walker?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
You will, Your Honor.
Let's see. Are we going on count 1 only, the state jail felony, not all the
It's a
others?
state jail felony, yes.
Right, yeah, but there's all
Yes,
these
we're going-
priors.
Yes.
Count 1 would be the previous invading.
Now, hold on a second, let me get this pulled up right. Mr. Walker, the state has elected to proceed on count 1 only. It alleges that you committed the offense of evading arrest or detention with previous convictions from October 19th of 2024. It alleges you were previously convicted of evading arrest or detention October 21st of 2011. And how do you plead to that charge? And is that prior conviction true? Did you enter your plea of guilty freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Walker is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of evading arrest or detention with previous convictions. Sentence you in accordance with your agreement to a term of 12 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. All right? Good luck to you, sir. You can go back with the bailiff.
Thank you, Mr. Parker.
Thank you, Mr. Parker. Good morning, sir. Are you Bryce Bordeaux?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Bordeaux, you're charged with the second-degree felony offense of robbery, and that's from March 18th of 2025, and that's cause number 250444. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them, that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $500 fine, and then we would wait for the PSI and see if there was any type of recommendation for safe P or treatment, and then I would make that determination. Is that your understanding? Also, do you understand, if you are not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Bordeaux is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent, you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. Then we'll come back at a later date for sentencing. All right, thank you, sir. You can go back with the bailiff. Yes, sir, thank you. Good morning. Are you Jacqueline Young? And
Judge, we had an agreement on this matter. Of course, it's an MTRP and a new law violation. The plea was for 5 years on both cases to run concurrently. After looking at it, when we did the plea paper, we realized that it was a significant difference in the credit that he has on the MTRP and on the new case. I was gonna ask, after seeing that and kind of talking to him about that a little bit, if I could get possibly 2 weeks so I can talk with him and as well as his mother. She's been pretty active in contacting. She's not here this morning, but.
yeah, I mean, I'll do that. You'll have to redo the paperwork. I'll have to delete all that paperwork. And obviously, the fact that I don't know that y'all can renegotiate, but I probably would not be inclined, just because he doesn't have credit on a
Right.
new case that he's on, to do that. But if you'll just explain that.
Right, I want him to totally understand what he'd be getting for.
Sure.
And it's not going to be a reduction in the offer or anything, Your Honor. He wants time to make sure he
Sure.
understands what he's
Okay,
saying.
we'll do a 2-week reset. Thank you.